Hey everyone, Judicial Watch President Tom Fitton here with our weekly update on social media from an undisclosed location, but there's a lot to talk about today. We have a court battle over the rights of a magistrate judge who was fired for defending the rule of law. We're in a court battle with the Biden operation in Delaware over his Senate records, and another major victory for President Trump in his efforts to get some accountability and transparency for the abusive, unprecedented raid on his home by the Biden team. First up, though, is the big news out of Florida. The federal court judge down there, Judge Cannon, has appointed a special master officially, Judge Deary out of New York, to examine the documents taken by Joe Biden's Department of Justice and FBI in its unprecedented abusive raid of President Trump's home. Now, to take a step back, Judicial Watch has been sensitive about this issue because, believe it or not, we took the position this Justice Department currently is taking when it came to President Clinton's records. He had records in his sock drawer, specifically tapes of conversations that someone had recorded of him conducting his presidency, including talking to foreign leaders, which is presumptively classified. And we thought, well, doesn't the Presidential Records Act apply to that? Well, we went to court and the court told us no. The Justice Department told us specifically, look, if the president has records after he leaves the White House, presumably they're personal. And that was the position of the Justice Department. The court affirmed that position. And they said, more generally, the National Archives has no business second guessing the president's decision-making in that regard. But along comes Trump and they change their mind, they change their position, they ignore the law, they ignore the Constitution, they ignore the precedent, and they ignore what the Justice Department had specifically told another judge, that records in the custody of a president after he leaves office presumably are personal because they weren't turned over to archives. Yet they went in and took those documents, pretending that they were government records, pretending they were classified, because if they're personal, it means they're unclassified. And President Trump objected on a number of reasons. He wasn't as direct as Judicial Watch was in suggesting all these records are personal, they had no right to go in there, but he's raised these issues both directly and indirectly in a way that's caused concern from the court. And the court has repeatedly brushed back the Biden administration's assertion that there should be no special master, which is an independent authority appointed by the judge, to examine these records as to whether they should have been taken by the FBI, meaning that they were covered by attorney-client privilege or otherwise personal, or maybe aren't even classified, as we're suggesting. And the Justice Department under Biden was horrified, and they were bullying the judge. They said to the judge last week, essentially, if you don't rule the way we want you to rule, doesn't matter how you justify it because we're asking for a stay here. If you don't grant it to us, we're going to appeal. Now, I don't know, I'm no lawyer, but my general understanding is you don't tell a judge you're going to appeal before you read the ruling. And the judge's ruling was issued last night. And she basically told the Bush Justice Department and the Bush FBI, the Biden, how quickly we forget, the Biden Justice Department and the Biden FBI, that I don't trust anything you're saying. I don't trust you on these records. I don't trust you on your protestations that if we don't investigate this as quickly as possible, there's the possibility of leaks. You know what the judge said? Well, the only leaks that have taken place have happened since the raid. Basically saying, you're the one leaking. So stop pretending that this is an issue. And they don't want anyone looking at the fact that these quote classified records. And the judge says, well, you're saying they're classified, but I don't necessarily believe that. And so we're going to take a look, because if they're not classified, if they're quote not government records, they're all his personal records, President Trump's. So this was a big victory for President Trump. It was another takedown of the Biden Justice Department and FBI by a federal court judge. The judge essentially told the Justice Department, as I said, I don't believe anything you're saying. I'm granting a special master. I'm appointing a special master. Now, in this case, the special master was agreed to by the names. There were 4 names suggested. There were 2 names suggested by the Biden operation and 2 names suggested by President Trump's team. And President Trump's team included a lawyer out of Florida and a retired or semi-retired judge out of New York, Judge Deary. And the Justice Department said they didn't have any problems with a former federal judge or a retired, semi-retired federal judge like Judge Deary. So that is the person who was appointed, Judge Deary out of New York. Now, the only controversy with Judge Deary is he signed on to one of the infamous FISA warrants spying on Trump. So he was misled on the Trump warrant, but on the other hand, he didn't hold a hearing on that. It wasn't necessarily a Trump warrant, it was for Carter Page, but it was directed at a spy operation targeting Trump. It was a forced spy operation, obviously, targeting Trump, but he didn't hold a hearing on it. So anyway, I guess the Trump team trusts him, the government trusts him, and so the judge trusts him. So we'll see how he handles the special counsel, this special master job that has been appointed to by Judge Cannon. Now, the other question is, and I don't think it's been answered yet, as best I can tell, is the Justice Department really going to appeal Judge Cannon's ruling? And are they going to go to what is the 11th Circuit Court of Appeals? And I don't know how that will run in terms of being for or against the Justice Department, but to me, they've kind of taken this arrogant point of view that they can't be second guessed by the judiciary. And the Justice Department should be deferred to by the judges, and the Justice Department should run the judiciary, especially with regard to this unprecedented act of abuse by the Biden operation. Now, taking a further step back, we have to recognize this is all part of a crisis as it relates to the rule of law caused by outrageous abuse by the Justice Department under Biden and the FBI under Biden. And as I've been talking about, you had President Biden's red speech where he essentially said that anyone who disagrees with him and or supports President Trump as an outlaw, basically putting a target on the backs of tens of millions of Americans. So concurrent with that, you have his operation raiding the home of the former president and putative candidate against him in his reelection effort. And then subsequent to that, you had dozens of subpoenas issued by the Biden Justice Department and the FBI out of a grand jury in DC, targeting people who dared to dispute the 2020 election. Now, their new theory is that if you were thinking about pursuing alternative electors because you had concerns about the electors appointed under the process in the 2020 elections, or the results of the 2020 elections has, officially put out there, that you were a criminal. That's their theory. It was a crime. So it's a vicious attack on the First Amendment. Your right to petition your government, your right to pursue redress under the law, under the Constitution, federal and state law. So I've talked about the Biden administration hurtling towards despotism. That's what we see here. And so it's up to, in some ways, obviously, there are many checks and balances when you have abuses of power like that in our Republican system, and hopefully they work here. And in this case, you have a judge saying, hold on a second here. We've had this unprecedented raid on the president's home, and this isn't going to be just another day at the office for the Justice Department. No, there's going to be accountability and transparency, and it's accountability and transparency the Justice Department and the FBI aren't used to. So essentially here's what the Justice Department said is, you have to trust us, Your Honor, on all these records, even though there's evidence we took material we didn't have a right to have, including hundreds of pages of classified material, medical records of the president, accounting records of the president that weren't responsive even to their outrageously broad subpoena. And this is what the judge wrote. In many respects, the government's position thus presupposes the content, designation, and associated interest in materials under its control. Yet, as the parties' competing filings reveal, there are disputes as to the proper designation of the seized materials, the legal implications flowing from those designations, and the intersecting bodies of law permeating those designations. So what the court is saying is, you, just because the Justice Department has alleged all of these horrible things about President Trump, the rule of law is I don't have to accept all of that as true. If there's credible information, obviously they're going to take a look at it. But there's been this repeated failure of the Justice Department to reassure the court that they're on the up and up. And further down, she talks about how they're worried that this is classified information, and the sooner they get to it, the better. This is like a key part of the ruling in terms of highlighting the Biden Justice Department's corruption. Mindful of the traditional reluctance to intrude upon the authority of the executive in military and national security affairs, so she's referencing the Justice Department's allegations that this material is classified, the court nonetheless cannot abdicate its control over questions of privilege and does not find the government's arguments sufficiently convincing as presented. First, there has been no actual suggestion by the government of any identifiable emergency or imminent disclosure of classified information arising from plaintiffs' allegedly unlawful retention of the seized property. Instead, and unfortunately, the unwarranted disclosures that float in the background have been leaked to the media after the underlying seizure. Boy, that's a judge saying, I think you leaked this stuff. Stop pretending that you have a concern about keeping all of that material sacrosanct. And so as a result, there's going to be a special master. He's going to go through and look at all this. And there's going to be a fight about whether the records are personal or governmental. And, I've talked about that before. I would take the position, strongly take the position that, look, according to the Presidential Records Act, which gives discretion to the president to choose what is personal and presidential, and according to the interpretation of that law by the court's authority at the Supreme Court level, at the appellate court level in the district, and in a key case, the Clinton software case that Judicial Watch was on the wrong end of, the president, there's no good faith basis to challenge the president's taking of records from the White House. The presumption is that they're personal. So that's what I would be saying to the special counsel. Now they may have, more ifs, ands, and buts when it comes to the special counsel's, the special master's analysis here, but that's the way I think it should go. But I don't know how it will go, because I'm sure the arguments will be more complex, and the president's lawyers will want a little bit more nuance, as they might say. And of course, what the Justice Department's going to be doing. But the important thing is that this will mean the case won't be resolved one way or another unless there's appellate intervention until the end, I think, of November. So the Justice Department was desperate to get this material out and to use it before the election, it looks like, because they wanted all this done by, the first 2 weeks of October or something, just in time for the November elections. Further proof that this was a political operation. So you have the leaks designed to make Trump look bad, designed to intimidate the court, proof that it's a political operation, the desire to get, quote, this information that's been supposedly sitting in the president's home for a year and a half, that became an emergency all of a sudden, and they needed to get it done just before the election, further proof it's a political operation. The attacks on the judge, further proof it's a political operation. This is not about the rule of law. This is a political raid by an out-of-control Justice Department and the FBI. And if you want proof of that, read the judge's ruling. You don't have to be a lawyer. All you have to be is someone with enough sense to see that there's a federal court judge who's fed up with this Justice Department, fed up with this FBI, and she's not going to be bullied by them into blessing something that on its face is suspicious. So this is how the court concludes. It's important, I think, that you hear this. Lastly, the court agrees with the government that the public is best served by even-handed adherence to established principles of civil and criminal procedure, regardless of the personal identity of the parties involved. It is also true, of course, that even-handed procedure does not demand unquestioning trust in the determinations of the Department of Justice. Based on the nature of this action, the principles of equity require the court to consider the specific context at issue, and that consideration is inherently impacted by the position formerly held by the plaintiff. The court thus continues to endeavor to serve the public interest, the principles of civil and criminal procedure, and the principles of equity. And the court remains firmly of the view that appointment of a special master to conduct a review of the seized materials accompanied by a temporary injunction to avoid unwarranted use and disclosure of potentially privileged or personal materials is fully consonant with the foregoing principles and with the need to ensure at least the appearance of fairness and integrity under unprecedented circumstances. Now, who would be opposed to that type of analysis? Anti-Trump fanatics. The Garland Justice Department, which is completely out of control. Now, this ruling, ironically, wasn't a perfect victory for Trump because the judge says, well, you can brief Congress, potentially in some of these records. So you can bet the Justice Department is going to use that to leak material to people like Adam Schiff up on the Hill. So I suspect that's going to be the next scheme pursued to misuse these documents. Again, further confirming that it was political. Let's go raid someone's home, give it to Congress. We're not allowed to talk about it, but once we give it to Congress, all bets are off. It's going to get out there. So this was a big victory for Trump. So what else is going to happen? Now there has to be a decision as to whether there's going to be, by the Justice Department, whether there's going to be appeals. That may delay things if they decide to appeal. But in the meantime, there's a special master appointed. And the process will continue in a way that ensures better, it's never perfect, but more accountability and more transparency and better protects the civil rights of President Trump. Because the left is angry that the court is worried about the civil rights of President Trump because they don't believe President Trump should have any civil rights. At least that's the way they behave. And on top of that, of course, Judicial Watch will continue its separate independent investigation of this improper raid. We already have a lawsuit about targeting the National Archives over records it has that relates to the raid. They're hiding records, so there's lawlessness there. And there's a whole host of other Freedom of Information Act requests that we are looking at suing on because they continue to ignore the rule of law there. So while at the same time as telling the courts and the American people that there's this core concern that they were trying to vindicate to make sure that records about what the government was up to, specifically as it relates to the President Trump's White House, that those be preserved so they can be shared with the American people, they are specifically ignoring the law requiring them to share documents about this scheme with the American people. Further indication that this is political. And it's up to, frankly, Judicial Watch to step in and do the heavy lifting to figure out or to get more of the truth about what's going on here. Sometimes I wonder if we should change the name of Judicial Watch to Hypocrisy Watch, because so much of what we do in terms of government transparency and accountability run up against hypocrisy. So you have the Biden administration, as we've been discussing, pretending that there's this document crisis with President Trump because he has records, right? And the records should belong to the American people. While at the same time, President Biden's records from his time as the Senate are completely walled off from any scrutiny by the American people as the result of a secret deal with the University of Delaware that is keeping them hidden from the American people. Now, Judicial Watch, along with the Daily Caller News Foundation, sued to gain access to these records and also to gain access to the terms of the secret deal that are keeping these records private and secret. I mean, for instance, you can have classified records potentially in records maintained by a senator. Are there any classified records there? Will the FBI raid the University of Delaware to see what President Biden has hiding up there from his Senate days? You know that's not going to happen. So it's up to Judicial Watch and our friends at the Daily Caller News Foundation to ask some of these tough questions. We're in court in Delaware State Court. Now, they've initially said, the court has, you can't get access to any of those records. So the court fight right now is over access to the secrecy around these records and the deal that's keeping them secret, which, you know, frankly, if we uncover that, you know, maybe it will kind of cause the release of all these other materials that we're also seeking. And believe it or not, we've been getting the court at the appellate level in Delaware wasn't buying what the University of Delaware was trying to sell in terms of suggesting that they could be trusted in saying, oh, there's no government money here, so therefore FOIA doesn't apply, and that Judicial Watch has no right to these documents. The appellate court wasn't convinced, and they sent it back down to the lower court, and they wanted more information. I mean, are we expected to believe that the University of Delaware kept all of their government money separate from any support for this records project with Biden? Does that make sense to you? Of course not. So they've been filing affidavits initially that the appellate court found wanting. And then they filed another affidavit, which really didn't answer any more questions that we found wanting. And now the court has required them to respond to our concerns. So I raise this issue because it's important to highlight that this fight about documents is outrageously hypocritical and lawless by Biden and company. They have a state-funded institution that is subject to FOIA, trying to hide from the American people virtually every record they have about their deal to keep the current president's Senate records secret. Now, what might be in those records? I highlighted classified information. One of the presidents, Tara Reid, who alleged that she was assaulted sexually by President or then Senator Biden, has suggested there might be records about her and other misconduct that has been alleged against Senator Biden in those records. He was head of the Foreign Affairs Committee, Foreign Relations Committee in the Senate. So he's talked about how he's had communications with foreign leaders and such while he was running that sensitive committee in the Senate. Well, what about his records with Putin and things like that? Those are the sorts of, and plus, you know, he's president, so there's going to be necessarily an interest. All sorts of people may have all sorts of questions about what's in his Senate records. That's why, you know, when Judicial Watch sues, obviously we're suing to vindicate our rights, and in this case for the rights of Daily Caller News Foundation, but we're there for you. We're there for all the media. We're there for all of history to get access to these records so the American people know what was going on under the president's term as a senator. You know, that's history, and we have a right to figure that out. It will inform us about what's happening now, and certainly it will inform us about the operations of the United States Senate. And you know, I go back to, and I forget who's the quote, but there's a quote about the founding father from the founding fathers about the right to public information, and he said something such as the American people have a right, an indisputable divine right or God-given right. So that this was an inherent right of the people to that, you know, essentially valuable yet knowledge that we probably don't want much information on, which is the conduct and the character of our nation's rulers. And so I love the sarcasm in that quote. But the fact is, we have a right to know the good, the bad, and the ugly about what our politicians and our elected leaders have been up to, because after all, they work for us. One of the other crises, and there's all these fires that have been set on the horizon, both purposely and you know, some of the fires have been spawned as the predictable result of left-wing and left-wing policies, which is one of these major fires is the crime crisis. And you have soft on crime prosecutors infamously associated with the Soros operation and that far left contempt for the rule of law and the rights of Americans to protect themselves from predators. And then you have soft on crime judges in the judicial system where the judges just don't want to enforce the law strictly or competently in some cases against dangerous criminals. And we had a case in Alexandria where a magistrate, former magistrate now, Liz Fuller, who's our client, kind of blew the whistle on some of this. And what had happened was someone was arrested for the rape or attempted rape of a woman, and he was almost immediately let out of jail, and he went on to kill her. And our client found out that the bail bondsman who helped get him out had let him stay at his house, and he actually used this guy's car, and I think it maybe even weapon, in the commission of this murder. And so she blew the whistle, got the bondsman held accountable. Someone asked her about it, so it was a separate case apart from her judicial duties, and she gave her point of view to a local newspaper, and she got fired in retaliation for blowing the whistle on what was going on there in the court and what had happened. So we're representing her in a civil rights complaint alleging that she was fired in violation of her civil rights, her First and 14th Amendment rights. And we just had a hearing on it this week because the government, the lawyers for the judicial officials that our client is suing, is trying to get the case dismissed. So the hearing took place this week before a federal court judge. I'm not sure how it's going to go. The judge asked questions of both sides, didn't give an indication, according to my understanding, of how she might rule. So we'll see what happens. But it goes to show that there's all sorts of permutations and work that needs to be done to vindicate the rule of law and address this crime crisis, which means also defending those public officials who are blowing the whistle as to what's going on. And here's some of the additional detail. A man named Ibrahim Alaki Bouyachi was arrested and indicted by a grand jury on or about January 13th, 2020 for burglary with the intent to commit murder, abduction, sodomy, strangulation, and rape of Carla Elizabeth Dominguez Gonzalez. Notwithstanding the seriousness of these charges, the Alexandria Circuit Court, which Alexandria is a suburb, essentially a stone's thrown away from Washington, D.C. in Virginia. The Alexandria Circuit Court released this man on a $25,000 bond, only $25,000 in April of 2020. Less than 4 months after his release on bail, Bouyachi on July 29, 2020, reportedly drove to Ms. Dominguez's residence in Alexandria and shot and killed her outside her apartment complex. And this is how we describe the issue. In the immediate days following the news reports about Ms. Dominguez's murder, plaintiff learned, Liz Fuller, from a police officer in the citizen lobby of the magistrate's office that the vehicle and gun reportedly used by Bouyachi to murder Ms. Dominguez belonged to the surety bail bondsman, Man Negan, who posted the $25,000 bond for Bouyachi's release. On information and belief, the bondsman and the officer struck casual conversation while they were waiting in the citizens lobby when Negan said that it was his gun and car that Bouyachi used to murder Dominguez, and he had let Bouyachi stay at his house while he was away on vacation. The officer subsequently relayed the information to the plaintiff, Liz Fuller, as part of the casual conversation among friendly colleagues outside any hearing or proceeding. So the point is, she didn't learn about this in the course of her judicial duties. She heard about it around the water cooler. And then on August 6th, Fuller, in her personal capacity, filed a complaint with the Commonwealth of Virginia Department of Criminal Justice Services, alleging that the bail bondsman had violated the rules and regulations of his licensure as a surety bail bondsman. And on September 1st, the bail bondsman's license was suspended and revoked as a result. And Fuller understood this concluded the matter. And more than a year later, a local newspaper asked us about it, got hold of the information by using the Freedom of Information Act. And they found out about her complaint. And they asked Fuller for comment. Fuller commented as follows. Negan came to work in the days following the murder, nearly boasting and joking about the fact that the gun and car belonged to him and Bouyachi had stayed at his home. And he was telling the officer about what happened and almost bragging about it. The officer said to me, "You will never believe what he just said to me." So I said, "I've got to do something about it." And 5 days after that story was 5 days after that story was published, Liz Fuller was placed on administrative leave, and she was fired on October 19th. So they accused her, in my view, well, actually in our view, falsely, of violating the rules that a magistrate shall abstain from public comment about a pending or concluded proceeding. There was no proceeding she was commenting on that was pending or concluded, or that was before her. In early 2021, she filed a grievance appealing her termination and denied it. So we're saying that her firing was in retaliation for protected speech, and the judicial canon used to justify her firing doesn't apply to comments made about a public filing made in her personal capacity. At all relevant times, Fuller was engaged in constitutionally protected speech when she made the comments to the newspaper, which undeniably addressed matters of public concern. Plaintiff enjoys the right to freedom of speech as guaranteed by the First Amendment of the United States Constitution. That includes the right to comment to the Alexandria Times as to her public complaint filed in her personal capacity about the misconduct of a bail bondsman and its outcome and the system's failure to protect a rape victim. So this was a rape victim who was murdered after he was let out of jail on a low bond and actually had been given access to this bondsman's car and a gun and killed her with it. And who gets fired? The magistrate who blew the whistle on it in her personal capacity as a citizen. And as I said in the release, the fact remains that an innocent woman is dead because she was murdered by a rapist who was let out of jail. The Virginia court should not have fired the magistrate who blew the whistle on the court bondsman whose misconduct enabled this murder. Our client, Liz Fuller, is a hero. Her constitutional rights were violated because she embarrassed Virginia court and political officials over their deadly soft on crime policies. That's what this case is about. So I tell you what, if this goes on, how are we going to control crime? If citizens who work for the judiciary doing their due diligence and doing everything we would expect a citizen to do to try to get justice for a poor woman who was murdered gets fired because she said, "This is what I did." Outrageous. So this is a federal case, and I hope the court lets it go forward, and I hope our client gets justice. But even if she doesn't get, you never know how a court case is going to go. You never know what the courts are going to do. But I hope you are educated, and this is some of the value of what Judicial Watch does here is this litigation. We obviously want justice for the clients, but the litigation is also important because it educates people about what's going on. And we don't put forward these allegations lightly. We think they're true, and people need to know about it. So this is a valuable public interest legal work that's educational, that hopefully will get justice, not only for our client, but indirectly for this poor woman who lost her life because of failures by the justice system that's supposed to take and try to take due diligence, take proper steps, reasonable steps to ensure that citizens aren't victimized and innocents aren't victimized by the criminals they're supposed to be protecting us from. So that's a great little case. And it's not even a little case. I think it's a big case because it also talks about the rights of judicial officials to speak out on matters of public concern without the ethics rules being used as a vehicle to suppress their First Amendment speech in a way that's completely improper. So just great work by our lawyers at Judicial Watch there. We had our legal team working on this. Several lawyers are involved in it. And what I love about Judicial Watch, I love like lots of things about Judicial Watch. I'm the president of Judicial Watch. I work here. But I get one of the honors I have, and what makes my job easier than it may look, is that, I come on, I talk about these cases. You're like, well, how do you know about these cases? How do you understand all this? Because the lawyers are doing the work. They're explaining it to the court, and then explaining it to the court, I'm able to understand it. Our investigators are figuring out what's going on. They're explaining it. And I get to talk about that work and convey that information to you. So it's just a great team we have at Judicial Watch. And if you like the sort of work that we're doing, I encourage you to support it at judicialwatch.org. You can obviously gain access to the information I'm talking about here and share the word, share the wealth in terms of educating other people that you know, your family and your friends, your churches, and your business community. But also you can support us directly, because the work we do is only possible because of the voluntary charitable support of hundreds of thousands of American citizens. So join our movement, join our cause, and join Judicial Watch. So with that, I hope you have a wonderful week, and I'll see you here next time on the Judicial Watch Weekly Update.
Thanks for watching. Don't forget to hit that subscribe button and like our video down below.